Thank you, Mr. Speaker.
I too want to say to you, Senatrice Boyer, how grateful I am, not only for the work that you do, but for this very powerful and necessary speech. Miigwech. Honorable Senatrice et
Honourable Senators, I speak today in support of Senator Couture's Bill S-251, which aims to repeal Section 43 of the Criminal Code. This section, as we may recall, in principle allows any school teacher, parent, or guardian to exercise so-called reasonable force on a child in their care. In 2017, I spoke on a similar bill by Senator Hervieux-Payette. My opinion has not changed. I am among those who believe that Section 43 is outdated and no longer has a purpose in our criminal law. The implicit and ambiguous message it sends is that force is still a useful, justifiable tool to compel a child's compliance.
of children implies our responsibility to protect them from any form of physical correction, regardless of its nature and intensity. Every Canadian, no matter their age, must feel and know that they are safe from their first day on earth to their last. The question of whether Section 43 should be retained or repealed is linked to how we truly choose to treat our children in Canadian society. Our criminal code is a living document that helps us collectively distinguish between what is acceptable and what is not. It regulates many aspects of our lives together on the basis of our value and principle, which are, of course, constantly evolving. The rule concerning the right of lawful correction was incorporated into the first version of our criminal code in 1892. As many have said before me in their speeches, it was a different time, a time when excessive force was acceptable in many aspects of society, including to educate children and discipline. Fort heureusement,
Fortunately, society is not static. It learns, improves, and changes through social experimentation, research, and the protection of rights. These social changes do not happen by magic. They are voluntary. These evolutions and transformations are reflected in the rules of law to reflect what's going on in society and reflect the reality of the moment. This exercise is what Bill S-251 invites us to do. Senator Gold, during the recent debate on Bill C-5, the bill to repeal certain minimum sentences, referred to, and I quote him, the exclusive jurisdiction of Parliament to set policy and make laws that govern the law in general. Senator Gold evoked the exclusive jurisdiction of Parliament in setting policies and making laws that govern the law in general. End of quote. Along the same lines, the Supreme Court also repeatedly recognized this prerogative of Parliament.
Our criminal code on several occasions on substantive issues, just to name a few. In 1969, the decriminalization of medical abortions. In 1972, the abolition of whipping as a criminal sentence. 1976, the abolition of the death penalty. And most recently, of course, the legislation of cannabis and medical assistance in dying. This exclusive competence of Parliament has been fully exercised on all these issues in order to reflect our ever-changing social reality.
This exclusive jurisdiction was well understood by the Senate. The Supreme Court had already ruled on the constitutionality of Section 43 and limited its use in 2004 in Canadian Foundation for Children, Youth and the Law versus Canada. 4 years after this important decision, the Senate even passed Bill S-251 at third reading, further limiting the scope and use of Section 43. That bill died on the order paper in the other place when an election was called.
Be clear, as we begin 2023, spanking is not banned in Canada. What the current state of law tells us is that it is prohibited to inflict punishment by means of an object or blow to the head of a child. Is this sufficient protection for all children? I don't think so, because as long as Section 43 exists, moderate bare-handed spanking of a child between the age of 2 and 12 will be tolerated, not prohibited in Canada. This is written black and white on the Justice Canada website under the title Criminal Law and Managing Children's Behavior. Let me quote the paragraph that answers the question, is spanking illegal? And I quote, "Spanking is a form of physical punishment that some parents use on children and, depending on the circumstances, could be illegal. Because of Section 43, spanking is not necessarily a criminal offense if the Supreme Court of Canada's guidelines are followed. However, in some circumstances, spanking could still be considered child abuse under provincial and territorial laws and could lead to action taken by child protection authorities." End of quote. Like many here, I am very uncomfortable with so many nuances and gray areas. I agree with the experts who tell us that it is not enough to discourage the use of spanking. It must simply be banned. And this bill gives us the opportunity. L'ancien ministre
The former Justice Minister, Alan Rock, in a 1998 letter responding to the Canadian Foundation for Children, Youth and the Law, said that, and I quote,
"No way condones or authorize the physical abuse of children. However, it does attempt to strike a balance by protecting children from abuse while still allowing parents to correct their children within contemporary limits that are acceptable to Canadian society." Fin de la citation.
End of quote.
Within contemporary limit.
Today in 2023, with what we know, what are these contemporary limits, which may have been acceptable even in 1998, and to which the minister refers, but which no longer are?
Century later, our contemporary limits have evolved, fueled by evidence-based research and our commitments to the right of children. Moreover, honorable colleagues, if, like me, you have asked yourself the question of how to interpret reasonable force, here is an answer provided by Professor of Criminal Law Wayne Renke of the University of Alberta, who states, and I quote, that as society evolves, so does the interpretation of what is reasonable. End of quote.
In light of these findings, the main question that Senator Couture's bill asks us is whether we, as parliamentarians of the 21st century, find it acceptable that a provision of Canadian criminal law dating back to the 19th century, which allows a parent or teacher to raise a hand against a child between the ages of 2 and 12, still has a place today in 2023. This is the first substantive question that this bill invites us to answer. The second question is whether Section 43 is a real protection or a useful and necessary means of defense.
The first, in which the responsible adult, in the urgency and need of the moment, has to use force for the children's safety. In this scenario, it seems clear to me that the adult is protected by the law. I find it hard to imagine that a parent or an educator who restrains a reckless child to save a child from an accident or injuries and injure him or her in the process, that such an adult really needs a provision such as Section 43 to protect him or herself from lawsuits, which are highly unlikely. Dans un scénario
In a different scenario, if the parent or teacher has intent to abuse, Section 43 may be of no use to a judge. It is, in this case, a false protection. So, if we act spontaneously for the safety of a child, we don't need Section 43 to protect ourselves. If we abuse our strength and power against a child, Article 43 will not be able to serve as a defense. And since research and the times we live in tell us that no force is reasonable when it comes to disciplining a child, what purpose does Section 43 serve, other than to justify outdated ways of acting and perhaps justify our own insecurities?
Then remove it and leave it to the judge where charges are laid to determine the seriousness of the facts and whether correction is inflicted or force is used within reasonable limits. I hope that sending this bill to committee will be an opportunity to shed more light on how this means of defense has been used so far in court, under what condition, how often, and with what results. A study in committee would have the merit of updating our knowledge and legal interpretation of the concept of right of correction, self-defense, and use of force within reasonable limits. Je propose en termes.
In closing, I would suggest that there are no good reasons to keep this section, and conversely, many reasons to repeal it. Repealing Section 43 would send a message to all Canadians, a message that says that it is possible to guide a child's behavior without using any form of physical discipline. Thank goodness. The days when children were second-class citizens who needed to be controlled are long gone. The more we move forward, the more we talk about empowerment, personal growth, autonomy, and developing our the strength of our youth. And look at the results. Our young people are fantastic when they come here to this chamber and to our offices, full of questions, initiative, and curiosity. Should we not do everything to make sure that they blossom in complete safety?
Section 43, it's listening to science. Evidence-based science has evolved since 2004, when the Supreme Court made its ruling. There is now a better understanding of the psychological consequences of violence on individuals in all its forms. Modern expert opinion recognizes no educational value associated with corporal punishment. It is not only counterproductive, but above all harmful to emotional development. This has been, as you know, amply demonstrated by Senator Kutcher and others. Abroger l'article.
Repealing Section 43 would mean, as Senator Moody reminded us, compliance with our international obligations by giving Canadian children the status conferred upon them by the treaties and conventions we have ratified.
Repealing Section 43 is to respond to a call to action number 6 by the Truth and Reconciliation Commission. The Government of Canada is committed to endorsing all of the recommendations of the Truth and Reconciliation Commission, one of which is the call for the repeal of Section 43. This bill presents us with an opportunity to do our part, an opportunity that must not be missed.
I sincerely hope that this bill will be referred to committee quickly. I said in 2017, and I will say it again, honourable colleagues, we will not be inundated with hundreds of emails about this bill. That's okay. The key stakeholders can't even write yet, let alone vote, which shows how vulnerable they are. And therefore, to what extent we have a responsibility to protect them. The interests of adults must not take precedence over the protection of children.
From Nelson Mandela, and I quote, "We owe our children, the most vulnerable citizens in our society, a life free from violence and fear." End of quotation. Miigwech, merci. Thank you.